To put it brutally, if flight risk was not a ground for pretrial detention, no suspects that we investigated would have been released, so there would be no implication for pretrial detention in general.
Nonetheless, flight risk still plays an important role and is frequently applied, but mostly in conjunction with the risk of reoffending. It is rarely the sole ground for pretrial detention. And in the 59 pretrial detention orders we analyzed in the framework of this project, flight risk was the sole ground in only 2 pretrial detention orders.
In 62% of the mandates, flight risk was invoked as a ground for pretrial detention, but that was by far not the most used criterion. Recidivism was 93%, which is in almost all mandates, in all cases, and collusion was used in 72% of the cases. 3 criteria were very often used, all 3 together, which is not that logical because one of the 3 grounds would be sufficient to have a legally correct pretrial detention.
We were able to observe 2 categories of people that were overrepresented in the data that we've gathered during our study. The first one was persons who were homeless, and the second was foreigners. Both of those groups did not have a fixed place of residence in Poland. That's why I'm making a conclusion that it means that the courts are automatically using pretrial detention in their cases.
When we look at those criteria for assessing flight risk, when we look, for example, to the question of the ties to the community, one of the criteria for assessment of the flight risk, it is obvious that a foreign national who just came to Bulgaria would not have any ties to the community, and therefore his or her risk to be detained would be much higher.
The issue with flight risk and foreign nationals is that inherent in the test, how it's applied in Ireland for assessing flight risk, is that if you have ties outside the jurisdiction, first of all, flight risk is more likely to be raised as an objection by the prosecution, but also you're going to have a more difficult time trying to overcome that objection when you do have a property outside the state, or you do have connections outside the jurisdiction, or you do have family living in another state. So it's not necessarily that there's a bias, a conscious bias amongst prosecutors or amongst judges, but it's kind of built into the test.
Another interesting finding of the research was that apart from nationality, the socioeconomic situation of the suspect plays a major role. This is also linked, of course, to the fact that there is no fixed resident for the suspect, or the suspect doesn't have a fixed residence, which can also be grounded or can also be linked to the social economic situation of the suspect. Actually, we found out that in 84% of the mandates where a flight risk was used as a ground for pretrial detention, there was a problem socioeconomically of the suspect.
If you aren't in a position to have financial means, if you are homeless, how could you pose a flight risk because you don't have financial means to get on a flight or to get on a boat or to leave the jurisdiction?
This flight risk specifically plays a role, particularly with foreigners. We also found out during the research that there might be conflicting decisions between the judiciary on the one hand and the immigration service on the other hand. So a better coordination between those 2 services would be recommended.
We have recommended that the code, the Criminal Procedure Code, provides for a presumption of release, a very clear presumption of release. And in addition, we recommended that the code contains guidance for the courts on which facts they can assume that there is a flight risk.
It could be advisable for national decision makers, including legislators, to consider a review of the current frameworks governing pretrial detention with a view to expanding the application of milder measures. Furthermore, some promising practices from the juvenile justice context, like the court assistance, which assesses the social context and the circumstances of the individual, or the organization of social net conferences, could potentially be expanded to the adult criminal justice context.
Furthermore, we have recommended to develop new alternative measures the pretrial detention, that they will be able to secure the proper conduct of the proceedings and will not result in deprivation of liberty. We have already spoken with the Minister of Justice and told them that they should modify the circumstances enabling the courts to use pretrial detention. In our opinion, the Ministry should delete from the code of the criminal proceedings the circumstances connected with fixed place of residence, as it leads to automatic use of the pretrial detention in case of homeless persons or foreigners.
We need more detailed data on pretrial detention. All we have are the rates of those who are remanded in custody in pretrial detention in Coger Hill Prison. But other than that, we don't have enough data. So we think it's important that data is kept properly and that this data informs policy going forward.